you better check how you're handling yourself in here. This is, yeah, I'm talking to you. I am talking to you. I watched when I made my ruling, I watched exactly how you responded. That will not happen here, ever. Beal Properties versus Teresa James. And where are we on this case?
I have managed to get a job. I don't start again.
Okay.
I do a letter from the Temp Agency that shows that a tentative offer of a job. And yesterday I was here and got fingerprinted at a school
Okay.
that while I can't pay them now, I do.
So I see, how much is owing? I need a sticker.
Around 3,000.
Whatever. How much?
14, leave balance of $3,230.
And then how much is your monthly rent? 1,000. So we're gonna go up a certain amount. Have you been trying to work with the landlord at all to try to see if you can?
I contacted them just because this all happened within the last couple of days. So I did. Did you get my email?
I did. I saw that she did send me an email that she had finally gotten a job. I just hadn't been in the office for the past 2 days. Here I have been
Okay.
in person all over the state.
So I had actually asked her at advice if I should contact them first or we should, and I will ask you that now.
So, Your Honor, I didn't get a chance to keep the press for the case call. I am not in the position to extend anything at this time. I do know that with this client, I can communicate with them and see if this is a high number.
It is, but Ms. Jones has been working through some things. She's been trying to get through this, and she quite frankly appeared here on the first day without any hope, and she's now here and things have started to look up for her. So I will just say this, here's what I'm gonna do, because I'm gonna do what I want to do anyway. Sure.
So I am working, I should be able to reach out to Paul.
Right, exactly. I mean, there's a lot of other things that she may be able to do if they ever get any money. So what I'm gonna do is, over plaintiff's objection, I'm gonna give her one more adjournment to the 31st, allow you to talk to the landlord to see if something can be worked out from inside James. October 31st, 2025 time, 3 p.m. Okay, have a great weekend. Yes, ma'am. Court does call the case of Beal Properties versus Ebony Reese. She's here. Dismissal. Okay. Hello, your name? No problem. All right. Where are we on this case? What's
The past difference retained is $2,511.44. Court profit $175. Total outstanding balance is $2,686.44.
all right. Ma'am, how are you intending on getting this paid?
I had an agreement with the property management that because this isn't like what I pay every month. This is like a past due balance from they weren't charging me rent. And so now I'm paying my monthly rent and I'm paying an additional $600 every month to take care of the balance for them not charging me rent at all. And so because I was in a constant, well, we went to a couple of different property managers since then, but at the time I would call them, email them, let them know you guys aren't charging me rent. It's been months. I didn't get paid. And so this was what they came up with, but it's so high in our business. It's not doing good right now. And it's hard for me to pay what I pay monthly and the extra $600 to take care of this balance. And so
How many months have you been paying the extra 600?
I do believe that's when my client filed, because I do notice that the extra 600 hasn't been getting paid since September. So I think that they, well, actually, hold on.
So it was the six, so the 600 became a burden for, wasn't being paid.
No, it's not that it wasn't paid. I told them that my business has been not doing good right now, and we made an agreement not to do the 600. I told them if they could work with me for 2 months of the summer, then I would pay 150 instead of 600. And then, so that was being paid up until this court stuff, and I haven't paid until we came up with judgments to see what would go on and how much I was supposed to pay.
Gotcha.
So it just hasn't been paid since September.
So either the agreement, the payment agreement that she's been working on has to be codified in some type of writing, or
Yeah.
she, or um something has to be done. It seems like she was paying on it, realized her business is where it is, negotiated a lower amount for a period of time, and now is just trying to figure out where she's going to head from here and do whatever. So here's what I'm going to do. I'm going to adjourn this out 1 week now, knowing that, and then you keep in contact with Miss Lacy and see what can be worked out to try to get this in some formalized way for you. Okay? October 31st, 2025, time 3 p.m. Okay? Thank you. Haver Hill on Clark versus Jeffrey Thompson. Okay. Appearances?
P78292 for Haver Hill on Clark.
Your name? All right. And this is a termination. The basis for the termination is
The basis for the termination of it was that the defendant was served a notice to quit based on lease violation. Those were served to the defendant on August 14th.
via the attached letter. I do see that. All right. What's your position on this, sir?
Proceedings and whatnot, but I've been working with Lease services for South Central Michigan.
Okay.
They're going to go bid and have the resources available for the deed within the day. I think it's miscommunication that it said in their letter that they want me to meet with them within 10 days.
Meet with who? Who? They did?
Either match, but I don't really know. But I emailed the property manager a couple different times trying to set up the meeting. I have an outstanding relationship with them. They were not a team, they're great people. And she got back with me and she said that management wasn't,
That what?
man, they couldn't meet with me. So they were going to move forward with their legal process. And
What were they, for your understanding, what were they going to meet with you for?
situation that happened. I had an opportunity to tell them what happened. Like, they have help, but you know.
Okay. Anything from this side on that? Your name?
Next, there's the PA manager. I
Okay.
did reach out and responded, so let me know that I reached out to the regional manager and she declined to meet with him because like you said, it was kind of over her head at that point. I really just kind of wanted to cut ties and terminate the lease agreement. because of the damage, that happened to the property and, incidents that happened that, recurring incidents that have happened.
The incident that happened was his fault?
I can't really pinpoint whose fault it was from Vitzville Township's report when they came out to the property. They stated that they had a history with him. So we pretty much because of what they provided to the manager, she decided that this is something that's gonna happen again and get my daughter keep taking hits to the property with the damage. And then we have several of our residents that are trying to move due to the incidents because they feel safe.
What was the specific incident?
So it was not on site that day. I did receive a phone call from Dismissal Township. They came out, there was blood in several areas of the building. The fire alarm had been pulled from, fire department had been out, fire. The glass where the other finger is, it was broken. I believe they said they found him in a state of undress at a nearby medical facility. And like I said, they said that these are recurring issues. So because of that, the regional manager decided to just move forward and terminate the lease agreement.
You say you're working with legal services. Are you gonna file an answer to this complaint? Pardon? What were you saying?
Or trying to sleep at night, having this over your head. I've been working in legal services, but today Alex had mentioned that I guess it was the complaint was, he said, I think it was incomplete because section 6 had to go for it. But and they actually see some of the events. And it passed a couple days prior to that time. Because of things that I didn't want to do that evening, I was hit, and I tried to get any attention that I could that time from my neighbors.
When you say you were hit by somebody? So you're indicating you were a victim of a crime which caused this sort of escalation of things. Part?
I was scared, I just needed to get out of there, so
Pardon?
I was scared to get out of there. So I tried getting a hold of anybody that I could and no one answered, so, I mean, they probably have a camera too, that that person was there, I don't know. I just feel really bad, I just wanted.
All right, well,
Horrible things, we have some health issues that we're working with CMH on, but I keep on doing it up, but I think it's a great meeting. Came from across the hall, just came across last weekend with cupcakes of all things for Halloween.
all right. I need a written answer to the complaint. I'm gonna, if you get to Mr. Henry, they should be able to help you with that, but I'm gonna put this sort of on a fast track here. I need a written answer to the complaint by. So let's do it this way. By November, no, by the 31st. Okay, by October 31st, I need a written answer to the complaint. And then I'm gonna set this for a final settlement conference, the prelude to trial if we have to have it. I'll set that for November 4th, 2025 at 9 a.m. That's in-person proceeding.
So, so
Thank you. Thomas Berry versus Serenity Struman.
Good afternoon, Your Honor, either case 27292 for repairing the building.
Your name?
Afternoon, Your Honor, Mr. Reese.
All right. In this, okay. I almost hate to ask, but where are we on this one?
This, Your Honor, we are ready to proceed with the hearing. I don't know if you're prepared to do that this afternoon, or if you want to set it for another.
Well, I'd have to set it for another thing. I was unclear when these two appeared the last time as to exactly the basis for a lot of, well, a basis for the health hazard.
The basis for the health hazard, Your Honor, I would. That was kind of broad, you don't have enough of them. This, I was just retained on this case, a couple of days ago. The fact of the matter is the health hazard, as my client was seeing at the time, was the, number of dogs.
Was the dogs, right?
Quite frankly, I don't think that really applies to a health hazard per se. So.
Oh, I don't think it does at all, at least as was explained to me. I mean, you weren't here at the last hearing. Your client kept going forth talking about a violation of an ordinance, which clearly would not relate to a health hazard in this instance. The very fact that somebody has 4 dogs doesn't declare themselves a kennel, doesn't make it a health hazard.
Well, I understand that, which is why the drawing that, but the other claim in this was a 30-day notice to quit. That's where we proceed for that.
Just 1 second. Well, counsel, we got a problem
That's fair.
because the only demands for possession that I have as part of this case are a health hazard.
Your Honor, I have this, domestic privilege was
Well, which was what?
really defended. September 3rd.
Okay, and it may very well have been, however. I don't know how one. I, even if I took the notice, I don't know that I can do anything with it because the only issue that was raised to the court is the only complaint I have. So the only notice I have and the only complaint I have is a health hazard and damage to the premises. Which again goes to the dogs in the house. So that's the only complaint I have. I don't have,
Yeah, this should have been in there.
what should have been in there? Okay, so council will know what I'm talking about.
Yeah.
I have a health hazard notice. The only complaint that was filed was a health hazard complaint. I don't have a termination complaint. I only have a health hazard, which again relates to the dogs that hopefully we've cleared up. When she responded, she filed an answer based upon the health hazard complaint. That's all I have. Counsel, I think if he's gonna proceed on something else, unless he wants to try to pursue this thing with the dogs, this thing's gonna have to be dismissed and he's gonna have to start again. All right.
Understood, Your Honor, we'll refile it.
All right. Was there anything you wanted to say?
Did you get the letter that I wrote that was attached to the written answer?
I got everything that you sent in. Okay, but I mean, you know what? Yeah, sir, I'm gonna tell you what. You better check how you're handling yourself in here. This is, yeah, I'm talking to you. I am talking to you. I watched when I made my ruling, I watched exactly how you responded. That will not happen here, ever.
That's frustration with myself.
Then you frustrate out there.
Violence.
Case dismissed. You too. Oh, you're just gonna stay back there? Okay. Can you state your names, please? All right. You have him very well trained, ma'am. All right. What's the claim in this case?
We're entering into a consent judgment here. I was talking to the defendants and we've come to the, understanding and agreement that the outstanding rent retained possession right now is $475.01. Court cost of $214. Total outstanding balance is $689.01. However, the defendants have agreed to pay $1,000 on the 5th of November, and then the balance of their account arrears by November 24th, 25.
Is that all correct?
Assumption that I get a paycheck from the government.
Oh, good.
I did quite make that quite clear.
Yes, I recall this. I recall seeing you. I mean, I see people real, but now I have to get their faces.
Because they're not represented by counsel here today, that they do have 3 days upon which you enter this judgment that they could file a written motion to have it overturned if they find a valid legal reason as to why they cannot be held.
Oh, I'm well counsel. I'm well aware.
Yeah, I don't think that's the issue. The real issue is, are they gonna give her money?
Well, you did discuss going into test fee.
Pardon? Yeah,
Which is why we pushed that date so far.
got it. So the check doesn't arrive. That's an option. Is that? And but you can't get there until. So that's actually the backup plan for our federal government being shut down and not paying the people that work for us and everybody so hard and just deciding to leave them out lurching. Oh, I'm sorry. Did I say that out loud? Okay. So do you have any other questions regarding that? All right. So what I will do is I will enter that judgment for possession by consent with the writ date as specified in there. And then wish you the best of luck and just hope it comes through. All right. You guys take care of each other, please. The first written date is the 5th, I think, for the 1,000, and then it is extended out to later, the 24th.
That's fine.
Court does call the case of Arbor Meadows versus Doan Ho.
April Lacy for Upper Meadows. Your Honor, we do have a consent judgment in this matter that, Ms. Foley signed.
Your name? Okay. Have you read over this consent judgment?
Correct, it was, 9.
Okay, yes, you, on October 9th, you signed it. Do you have any questions regarding this?
Just pay the rent on time.
Yeah, yeah.
Okay,
Ready to be already, but I feel that.
everything, it's okay. So you don't have any questions regarding this? All right. And what I'm gonna do is I'm gonna enter this judgment. Ma'am, you do have 3 business days to think about this. If you think that there's some confusion or something you didn't understand, you can come to the court and file a motion or just a writing saying that you'd like a hearing. Okay? What's the day there? Thank you. That's done. What's this? This is that. Okay, thank you. Harbor Meadows versus Charles Carter.
Mr. Carter's in here.
Good afternoon, Your Honor.
Good afternoon, sir. All right, where are we on this case? What is,
If you're into a consent judgment with Mr. Turner, we agreed to, comply with the, agreement as far as paying his monthly rent on time for the next 12 months.
all right, is that correct, sir?
Yes,
And to abide by the community rules and regulations, correct?
yes,
All right, do you have any questions regarding this?
no,
All right. And were your rights under your 3-day right of rescission explained to you, sir?
no,
All right, I will explain it in its brief form. This is a consent judgment. You're unrepresented by counsel. You have 3 business days to think about this. If you believe that there's some legal reason, some confusion, or some right you did not assert, you would have to file a motion with the court within that time frame. All right,
Okay.
doesn't mean that I grant it, but you'd have to file a motion within the time frame.
got you.
Got it? Okay, then I will grant the judgment to the plaintiff
Thank you.
by consent as to defendant. You're Charles, correct?
Yes,
Okay, so by consent as to defendant 1, by default, but along the same terms as to defendant 2. All right, and I've signed that. Thank you, sir.
thank you.
Your name, sir? All right. And what are we doing?
Payment plan, I just $1,400 of the debt yesterday remains at remains at 47618, which I can pay over the next 3 weeks.
47618. Hold on a second. What do you have as this balance?
So I have $1,830.18. You pay how much yesterday, sir?
What's that?
1,400.
I got an email from Brittany Marshall.
That would, bring him down to $430.18 plus 175 for cost. So it's total is $605.18.
And when can you get that paid?
Nah, I need to pay 3 weeks. I said I have to pay rent for next month.
All right.
So this in 3 weeks?
No, not at all. I'll get paid on the 23rd of 1,300, but I'm trying to focus on getting this paid. Cause I don't, you know what I mean? I know I might have on the 3rd, I might have the amount for that month's rent as well as what's back paid, but I have what's back paid owed.
All right, here's what I'm gonna do. I'm gonna adjourn this to October 31st, 2025 at 3 p.m. See if you can work something out with your landlord regarding your payment plan. If not, I'm likely gonna enter a judgment on that date that will extend your time out some to try to get this amount paid without clicking into November. All right? She's gonna hand you a card, give her a call, see if you can work it out.
I'm asking some assistance, but I got like a rental lease product with them as well.
Pardon?
Is there somebody I can get some legal assistance? What's my
Did you see the video that played?
Yeah, some forms.
The form?
Taking camera, take pictures of the coach.
People do it all the time, regrettably. You got something? We'll get that to you, sir. Okay? See you next week. Call Miss Lacy, see if something can be worked out. 3 p.m. That's what? I never liked the holiday. All right. Where are we on this case? This is,
We took a judgment on October 10.
yes.
And the defendant filed a motion to set aside the default judgment, saying she had some issues making it to the hearing, doesn't believe she owes 10 grand, and she would be out by, trying to read her motion, I think it's October 20, and of course, she's not out. We have now filed, she's not filed the bond. We have now filed a motion, I'm sorry, an application for an eviction order.
What do you want to tell me? Because it does say that you were going to be leaving in any event. Pardon? You did? So you're out of the apartment? Okay. And so what you're doing is you're challenging, saying that you don't owe that amount of money. How much do you think you owe?
200 and something, she said, for rent. And then, damages, which is 200.
Which is,
Under 500.
you think you owe under 500, they think you owe 10,000. Did you pay the last month's rent? Were you terminated from Mischief at all?
No.
Okay, well, at this time, you're out of the apartment. And at this time, I do have. So possession's been surrendered. Have you have documentation that you can submit to the court that in terms of payments on the account?
I'm not sure what payments I was supposed to be.
Did you have any portion you were paying? All right, then what you need to do is you need to get to Mischief or whoever your worker is, get to the quarter ledger that indicated that they paid your rent and that you weren't terminated or they suspended your subsidy. Okay, so what I'll do is I will put this over, I'll give you 2 weeks to get that into the court. You need to send a copy to opposing counsel, so I'll adjourn this to November 7th,
I've also submitted
2025 at
1 p.m.
1 p.m. I'm sorry?
submitted to her lawyer, the pictures, because she had like that's probably if she wouldn't retain to this files in her property for so long, because she wouldn't come abide by the rules, and she couldn't pass inspection for 3 months. So that's what I remain.
All right, I'm going to decide your motion. You've already given possession. Defendant has given possession. And then in essence, the only thing that you're challenging is the amount of the money judgment, but I'll take a look at that. I would imagine that most of this may be rent that wasn't paid, or at least a portion of it. So you need to provide that to me and provide any other documentation that says that the unit, that you didn't cause any of the damages they're claiming. Understood? All right, we'll see you in a couple weeks.
On the,
All right.
at 1 o'clock, Your Honor,
Yes,
right?
sir. Yes,
Thank
sir.
you, Your Honor. Have a
Thank
nice
you.
weekend.
You do the same. Good afternoon. Your name? Okay. I know, that was the student attorney, but he stopped.
Your Honor, first of all, I can't hear what's happening in the courtroom.
Okay, I know. Our system is partially down. I've been operating with this all day. I will repeat whatever I can repeat that may be necessary. So, but
Okay.
you go ahead. I can hear you.
Okay, great. I'm Ike Start. I'm here with my partner Anushka Jalaseki. We're student attorneys requested to appear on behalf of Ms. Ellison pursuant to Michigan Court Rule 8.120 under the supervision of attorney Santa Crochet. who I believe is here by Zoom.
I see him.
Okay.
Have
good.
you been before me before?
No, I have not, Your Honor.
Where are you from?
Originally from the Grand Rapids area.
Okay, so you're Michigan.
That's
boy.
right, Michigander. Yeah.
Yeah, all right. Where'd you go to undergrad?
I went to Calvin University, which is a small liberal arts college in Grand Rapids.
It's like people think I'm like crawling from under a rock. I know where it is.
Okay. Most of
She's like I don't go anywhere. All right. Jeez, oh Pete. Okay, now you're at U of M. All right. I guess I'll give him permission to practice. Permission to practice is granted. Go ahead.
Thank you, Your Honor.
All right. Where are we on this case?
Yeah, I'll take it. Since the last hearing, we've had fruitful discussions with Ms. Gannon. And I don't want to speak for Ms. Gannon, but I think we're very near to a resolution on this case, and we were discussing a conditional order of dismissal. We've talked to Misja, and they've agreed to pay a large portion of the back rent that's allegedly owed in this case. Our client, Ms. Ellison, has an appointment with Hawk on Monday to try to generate some funding there. In addition, we know that it's important to Ms. Gannon that Ms. Ellison be leaving the apartment complex, and so Ms. Ellison is actively looking for and applying to other housing options. So I guess at this point, we'd request an adjournment for another 2 weeks. That being said, Ms. Gannon and I and our team are I think pretty close to getting a resolution here. So if we draft a conditional order dismissal, we can file it and cancel the hearing if necessary.
You can tell he goes to Michigan. He talks a lot. No, but I actually understood it. He didn't use any of those big words those Maryland guys can't understand. Ma'am, is all of that correct? See? Simple, to the point. All right. Will a couple of weeks be enough for you guys to get this done, or you think?
Yes, sir.
All right. Okay. I will adjourn the matter to November 7th, 2025 at 1 p.m. Okay?
Thank you.
All right. Thank you. Have a great weekend.
You too.
All right. And good luck to your football team.
Thank you.
All right. Court calls the case. Group 5 Management versus Winston Johnson.
Afternoon, Your Honor. Robert Weiss, Wayne State University.
Yes, sir.
Mr. Johnson is not checking.
Mr. Johnson has not checked in. Did you wish to take a default, sir?
I do, Your Honor.
If you raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
The amount owing is $253.42 inclusive of court costs. Requested judgment for possession and money judgment in that amount. Writ to issue in 10 days.
You said 253?
253.42.
42. So that's basically court cost.
Yes, a little bit more than court costs.
Gotcha. Very little bit more. Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. No writ without a hearing.
No writ without a hearing?
Yes, sir.
Okay.
I do that when the balance is really low. Maybe they just forgot to pay it.
Who does
All right.
Maryland play this week?
I have no idea. They've disappointed me the past 3 weeks, so
Yes, I know.
I
was thinking about you when I saw the scores.
So I've been crying and not looking at their schedule. I'll figure it out tonight, though.
All right.
All right.
Have a nice weekend, Your Honor.
You do the same.
Okay. Bye.
Bye. Dave Petta versus Seth Burton.
Good afternoon, Your Honor. Paul Buss on behalf of the plaintiff, Dave Petta.
Your name? All right. And where are we on this case, folks?
So, Your Honor, Mr. Barton raised some defenses at the last hearing 2 weeks ago.
We instructed him to file an answer to the complaint. I never received that. Yesterday, I called with my assistant, called the court, and we saw that he did file something yesterday or the day before. So the clerk here was nice enough to email the answer to me. I got it up yesterday. There's a lot of allegations in there. Mr. Potter, I did also get the answer emailed to me overnight after midnight, and apparently he taped something in this case, which I believe is the answer to a loading dock door at Thompson's Farms where my office is. I just got that notice when I was sitting in court here. Basically, in his response, he admits that he has vacated the premises. He's abandoned the property. He's done that since the beginning of July.
Can I reject that? That's nothing like what I said in my statement.
Oh, okay, let me just, because that's what I kind of gleaned from this. Are you in the property or not? Pardon?
House is filled with mold. The water filtration system has been disconnected and the pipes are still leaking into the base. Trying to get my stuff out of there as fast as I can. Working on it.
Okay, so you're not living in there, but you have property there. All right.
It's covered in mold, so in order to move it, it needs to be cleaned, or I can bring it into my new house. And I got a staph infection from dealing with all the mold. That's why I was late turning in the paperwork. I have a doctor's note, easy clean.
So, Your Honor, the most important thing here is that my client get access to the house to remediate the problems that are in there. There's no debate that there are problems. How those problems are caused, those are up for discussion, because we believe that defendant significantly contributed to the mold problem by not allowing access, not allowing remediation.
Okay, look, this is not a trial, so the whole objection thing that you see on TV, not helpful. You wait till I tell you you can talk. Go ahead.
So what we're looking to do, my client has notified his insurance company about this whole problem here. And they said they're actually going to drop him by the end of the month if he does not get in there to remediate the problems. So what I guess I can do under the lease, if he's not saying that he's moving out or moving out his possessions, to the very least, I can exercise some language under the lease that says that we can get in there with 24-hour notice to tenant. So we're giving 24-hour notice to tenant that we will be in there on Monday morning to start remediating this. And his possessions in there, you can see that it's quite cluttered from the pictures that were attached to his answer. Some things are going to get moved away from the furnace and other things that need to be repaired. We will not throw anything out until further order of this court, but we are going to be getting in there to remediate this immediately.
Go ahead, sir. What do you want to tell me?
I never given them from access to the house. They've got keys to it. The lock is the same. The only thing I did was disconnect the garage door because every time I kept coming over there, it was wide open with all my stuff there for somebody to take.
Okay.
Also went into the house, all the windows, left all the doors unlocked, and a lot of my stuff got rained on now the last couple of months. And that's been ruined upstairs where there wasn't even a leak from the pipes. That's also shown in the picture.
What, they left the windows open?
Lock all the doors, turn all the lights on, and pull the screens up, open all the windows, and not rain inside the house, Your Honor. My couch is now ruined. I've got a laptop that's ruined. A bunch of other stuff got wet. And this has been going on since.
Okay, so in terms of their notice that they're entering the premises to remediate, you don't have an objection to that. Didn't ask you whether you ever did. Listen to my question. I don't need the superfluous language. You do not have an objection today, correct, to that? All right, they will be entering the property. They will be able, for the purposes of remediation and protection of property and preserving the property pursuant to the court rule, I think it's 4.201H. And you are not to destroy or remove any items except by order of the court. All right. So if you want to prepare an order to that effect, which we may need one just in case, I certainly would appreciate it. And then when do you guys want to come back? Because you're gonna have to have time to review thoroughly the answer that has been answered and presumable counterclaims. 2 weeks, will that work for you, sir? During this matter, November 4th, 2025, 1 PM. November 7th. I don't know, why am I writing the 4th?
Because it was a Tuesday date?
Oh, you're right. 1 PM. Okay, so I haven't completely lost my mind. All right, thank you. Court calls the case, Bell Asset Management versus Skylar Asher. Hmm, Go ahead.
And case P 7292 for Bell Asset Management and Medina University, since everybody else.
All right. And your name? All right. Last time we were here, or this case was called, there was $3,716. Is that where we still are, or?
Basically, Ms. Asher, at the last hearing, we were just, that is the right to retain if she wanted to stay in the unit. However, she said at the last hearing that she had vacated the unit, forgive me if I'm wrong, correct me if I'm wrong. Yes. And she has nothing left in the unit. And she reiterated that to me today. Unfortunately, it took a little bit of doing, but we actually do have, we filled out a conditional dismissal, but it just basically says that she's,
Well, why would we do that? Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes. All right. You are no longer in the unit at 120 South Prospect Street. Okay, and you voluntarily are surrendering that to the landlord, Bell Asset Management? But you are surrendering the premises and any right to the premises? And so they may re-enter the premises? And anything that is left in there that may be property of yours, would it be okay with you if that is defined as abandoned and that they may just get rid of it? All right, I think we're done. You can take possession of the unit and I can dismiss this case. All right. Yeah, no, I know you're trying to get there. After that last case, yeah. All right, thanks, guys. You guys have a great weekend. Casey Zhang versus any and all occupants at the 383 Sedgwood Lane.
Your Honor, in P 7292 for.
Okay. And you're an occupant in the premises?
Your Honor, if I may.
Yeah, please.
I believe that we need to set this matter for another hearing. She has presented me with what ostensibly is another addendum that wasn't in the file that was provided to me that extends this lease, so I'm kind of lost too.
All right. Is that correct? You gave him something that might change. I don't need to say it, but you did do that? All right. So I can go to 31st or the 7th.
If we could go to this, what was the second date, 7th?
7th, November 7th.
Because I have a young child that wants to celebrate the event.
So do I, but I gotta be here. What? No, never mind. I'm kidding.
No, it's not now, your holiday.
What'd you say? Well, I don't, I don't like people coming to my door wanting things. That's just me. All right. I'll adjourn this to November 7th, 2025 at 1 p.m. All right. Pardon? Yes, in person. All right. Thank you, ma'am. Trails versus Jordan Oren.
Good afternoon, Your Honor. Christopher Borgen standing in for Attorney Record City Katz.
Your name? Okay. You know, you can get hurt wearing those colors down here this Saturday, but go ahead. Just saying. Just trying to help you out. Okay, where are we on this case?
Your Honor, currently there is a balance due. We show 1652 inclusive of court costs.
Okay, so that's right, because you paid the 3 down, then the month clicked in.
I paid $16.50 this afternoon.
Okay, he said he's paid $16.50 this afternoon. I tend to believe him because he came up with the 3 grand when he wanted to. You had the receipt. He's going to show me a receipt. I'm not going to take it from him. I'm just going to say this. Let me just do this. Let me adjourn it to the 31st, 2025 at what time? At 12 noon. They'll look at it, and sir, if it's paid, they're going to dismiss the case. Okay? Thank you.
Thank you, Your Honor.
Court calls the case of Willow Ridge Apartments versus Chandra Kubar Kayan.
Christopher Borgen for the plaintiff.
Your name, sir? Okay. So how much does plaintiff have owing at this point? Well, this is a judgment.
Yes, Your Honor, I believe this is defendant's motion. We do have a
Does-
resolution, however, in this matter.
Okay,
but
go
we-
ahead.
Just to confirm, Your Honor, is this 3287?
Yes, sir.
The case? Thank you. So the parties would, I believe, this is through Mr. Katz, stipulate to the following. The balance of $7,021, that's inclusive of October rent, would be paid on or before October 31st. If that is the case, the writ would be quashed. Additionally, we would say that the writ would not be executed until November 1st, giving the time to pay. And if that is the case, we would submit the paperwork to quash. We're happy to submit an amended writ or whatever the court thinks is best.
The total 7,021 so balance now, and during paying the motion I paid 1,400 1 month rent. I have with me 3,470 with me.
You have 3,470 with you? No, I heard you. Go ahead.
So 1 month rent I paid as a motion, and I have 3,470 in my hand. So I don't know whether I can pay in the cash to the court. I can pay now, right now.
No, you can't pay it right now because the court's closed.
Yeah. 470 with me.
Okay. Are you going to pay everything by the end of the month?
Yeah. This month I can pay.
Okay. Then here's what I'll do, counsel. I think the better way to do this is you need to pay your entire balance down to 0. I think that's the intent of this. And I'm going to give you to October 31st, 2025, 1 p.m. noon at 12 noon. I'm just going to adjourn it to that date. You need to get it paid down to 0.
So downward month rent already added in the portal. So that's when I'm able to pay.
You need to get yourself paid through October. I think that's the intent. Is he's got to pay through October, correct, counsel?
Yes, Your Honor. Would it be possible to help him a bit to release escrow to the plaintiff? He's only paid 1,000 so far, I show.
Oh, I got you. I see the escrow there. Yes, and I will release the 1,400. I'll release escrow to plaintiff.
Thank you, Your Honor. Should we submit an order?
No, you're good.
Thank you.
All right. So do that with the 1,400. Get yourself paid down. and you'll be good. So the 1,400 that you put into escrow, we're gonna pay that to your landlord. Yep, I'm gonna pay that to your apartment. You have to pay the rest up, get your balance current through the end of October. And then you're all set.
So just there are not many penalties, I just put it back out. Is it possible to reduce anything little bit, some like late payment penalty they put?
You'll have to talk to them about that. But you need to get the amount in. My understanding is there's an agreement which sum and substance says you're gonna pay it through the end of the month. Okay? Thank you.
Pay back the rest, right?
Say again?
On before 31st October, apart from the 1,400, I need to pay down.
Yep.
Yeah.
That's it. Thank you.
And Your Honor, just to be clear, on plaintiff's end, the motion would be held in abeyance, no determination
Yes,
today. We're just-
there's no determination at this time. Thank you. Willow Ridge Apartments versus Steve Nzumba.
Christopher Borkin for the plaintiff.
Nzumba, what'd you say? I have nobody here on that. Would you like to take a default?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear a firm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Go ahead, sir.
Thank you, Your Honor. We would request a default judgment. This is possession only. Rent to retain is $1,040. Court costs are $175, making a grand total of $1,215 due as of today. We would request that amounts paid in full on or before November 3rd or a writ be issued. To the best of my knowledge, the property has been habitable during the time of the lease. The defendant is not a minor, nor incompetent, nor in active military service.
Judgment to the plaintiff, that's by default for possession, redemption amount, in the amount requested with the writ issue in 10 days. And let me call these Willow Ridge Apartments versus Angela Smith, Willow Ridge versus Abdallah. Those matters are dismissed on plaintiff's motion without prejudice. All right. Thank you, sir.
Thank you, Your Honor.
Have a great weekend.
You too. And I have to say, now that those U of M folks left, go green.
Oh, man. See, I like Borkin until then. I really did. All right. Take care.
Have a good one, Your Honor.